Hi, my name is Athirah Binti Zaidon, and I will present about the case of Stirland versus Director of Public Prosecutor. Um, the issue in this case is whether evidence of such previous conviction was admissible in this case, and whether the evidence of character was properly admitted. The fact of the case is that the appellant was convicted in forgery and he then gave the evidence. Then, the appellant called a witness to say that he was a person who had never been convicted before this, and he was moralistic. He put a good character in the issue when he cross-examined in the prosecution of witness. In cross-examination, appellant was asked whether he quit his job after being questioned about signatures and forgery, and he refused to this. The judgment of the court is that the court held that previous conviction evidence was inadmissible and the character evidence was not properly admissible because of cross-examination was irrelevant and unfair to the charge, and tended to show that the appellant had committed an offence other than the present one. There was no abortion of justice, and the appeal by the appellant was dismissed. As an argument, Winfield's proposition was not referenced in the judgment and that conviction should stand. In my opinion, I agree with the decision of the court in this case. Since the appellant claimed good character in evidence, he could be cross-examined. I agree that mere suspicion was not relevant and enough to establish his bad character and to deny his good character. In this case, the appellant did not mention that in previous he had never been charged of the crime, so that the question should be justified as challenge to the appellant's veracity, and as seeking to show that he was a person not to be believed his own oath. Therefore, the previous conviction was not admitted, and the appellant's bad character cannot expect to put only the good part of his character. The general rules embodied in Section 54, Subsection 1, which state that in criminal proceedings, the fact that the accused person has a bad character is irrelevant, unless evidence has given that he has a good character, in which case it becomes relevant. There are sections under Section 54, Subsection 2, which is as enumerated in Section 54, Subsection 1 of Evidence Act. The gist is a person charged and called as witness shall not be asked, and if asked, shall not be required to answer the further question, which is tending to show that he has committed other offences. Secondly, when he tending to show that he has been convicted of other offences, and tending to show that he has been charged with any other offences, and lastly, tending to show that he is of bad character unless it falls under one of the circumstances in subsection A and subsection C. Subsection C. The most important thing that evidence with bad character can only be led if the accused brings evidence of his good character. This can happen if the accused brings evidence of good character when testifying in court or through the testimony of other witnesses. In this case, appellant could not object to a question which tended to cast doubt on the veracity of the evidence. Therefore, evidence of bad character will not be admissible, as it may mislead the jury into false issues and show that appellant has committed similar offences before and which may result in criminal misconduct against him. In the case of Sylvie versus Director of Public Prosecutor, it was held that as there was a real issue about the conduct of an important witness which the jury would have to settle in order to reach their verdict. The judge in the case had exercised his discretion correctly to enable them to know the previous record of the man on whose word the complainant character was being imparted. In the case of Rex versus Turner, the court held that it is no disproof that good character of a man has been suspected or accused of the previous crime. Such questions as were you suspected or were you accused were inadmissible as they are irrelevant to the issue of the character, and can only be asked if the accused has sworn expressly to the contrary. However, there was still no reason for questioning the appellant's conviction for forgery, even though the evidence were inadmissible. According to the case of Wilmington versus DPP, the court held that the appeal was dismissed if there was no substantial miscarriage of justice in convicting the accused. In this present case, I found that no such application was made under the case of Rex versus Latham. There were no substantial miscarriage of justice in convicting the accused, and it was inadmissible of evidence did not result in fatal to the conviction. To conclude, the conviction for forgery which the appellant did should stand, and the appeal should be dismissed. To the end, the character evidence in this case was not properly admitted. Thank you.